Hey, folks, thanks for joining another episode of the Frank Figliuzzi Show. I'm thrilled that you're here and even more thrilled that my friend, colleague, Glenn Kirschner has decided to graciously accept my invitation to join us today. You know Glenn, he doesn't require a lengthy invitation, but you know him as a former assistant United States attorney in the District of Columbia, a former JAG lawyer in the Army, and most of all, a true champion for justice. Many of you, perhaps tuning in right now, are part of his Justice Matters coalition. Without any further ado, let's bring Glenn in. Hey, Glenn.
Frank, great to be with you.
Yeah, thanks for doing it. I know it's a busy time, and it seems like every time you or I try to schedule one of our shows, there's another piece of breaking news, and we should probably cover something that happened this morning. You may have already done this on the show, but that is the FBI executing a search warrant at the home of Virginia State Senator Louise Lucas this morning. Louise Lucas is the Senate pro tempore, Senator pro tempore, often talked about as the highest ranking or most influential Democrat in Virginia. And she is behind and led the redistricting efforts that got Virginia Dems for what could lead to 4 congressional seats in the redistricting. And lo and behold, this morning, the FBI shows up with a search warrant. Any thoughts on what is going on here?
Yeah, I have a lot of thoughts. I have a lot of reasonable inferences that I'm willing to draw, but I hope that this state representative, I don't hope. If she has a dead body in her bedroom closet, somebody she has murdered, then I would fully expect a search warrant would be issued. You know, the abuse of the rule of law by the Department of Justice leadership is so transparent, and it is now so frequent. We've had bogus subpoenas issued, grand jury subpoenas that have been quashed, fancy word for thrown out, invalidated by judges. We've had indictments of folks who committed no crime. We've had them throw out. We've had judges throw those cases out, and I suspect there will be more to come, like the James Comey 8647 indictment. You know, the abuse of power by Donald Trump's dirty DOJ leadership is in our faces. Right. It's right out in the open.
So this is what leads everyone to just think that this is all bogus. It's not that, look, they might, as you said, they might have a dead body in her house, or as the press is reporting from sources, that this is some form of federal corruption investigation. And maybe so, but the timing of this and all of these others that you recited, this leads the public to think DOJ is no longer credible. I don't know. We'll talk about the Comey case in a minute. But between this and the SPLC, Southern Poverty Law Center case, it's just getting to the point where this appears to be vindictive. When you awaken in the morning to reports that you're being searched by the FBI, she was somewhere else. She drove to the location. You're 82 years old. She's 82 years old. And it's well known that she is very outspoken. I mean, very outspoken. You and I are outspoken, but Miss Lucas, Senator Lucas, has been very outspoken against Senator Trump and other high-ranking Republicans, including Senator Ted Cruz in Texas. And here comes the Bureau. And you just have to wonder what was said to a magistrate, what was said to a grand jury, what is going on. But yeah, I thought we'd cover that before we get into some of the other kind of outrageous. I want to start by getting real close and personal with you. You were an assistant United States attorney for how long?
24 years, and I was an Army JAG prosecutor for 6.5 years before that.
Yeah, and I, obviously as an FBI agent, 25 years, worked, joined at the hip with assistant U.S. attorneys wherever I was assigned in the country, and knew them to be of the highest caliber, integrity, experience. And the thing that you already knew when you were going to walk into an AUSA's office is that they may be new to this particular case, they may be new to the unit they were just assigned to, but they had the foundation of prosecutive experience. And that seems to be gone. There's news now, and we have a headline that we can put up on this, that DOJ cannot hire AUSAs. They just can't recruit to one of the most prestigious positions in the Department of Justice, that line AUSA, and it's so bad that there are now reports that they are offering $25,000 signing bonuses to pretty please, begging. They're hiring out of law school, which was kind of a big no-no. That's astounding. It's rare. It was very. Let me say this. It was rare. What condition is the state of federal prosecution in right now, and what does it do to the credibility to have someone, a 3L out of law school who's going to go and how about do the Jim Comey grand jury presentation?
So, Frank, I'm going to start with a point of light because, we are living amidst the Trump-induced darkness, but I'm always looking for that little bit of silver lining that is lurking behind the big orange dark cloud that is Donald Trump. Here's the point of light. The fact that attorneys, that new law grads don't want to go to the Department of Justice is heartening. That fills me with optimism that they see the Department of Justice for what it is. Yeah. It has corrupt leadership, and young lawyers, new law school grads, do not want to be involved in that. That's a point of light.
No, you're right, and kudos to you for seeing the brighter side of this picture. I'm in the dark right now on this, and so you're right. We have people going, nope, not doing that. No, I can wait. I can hit the pause button for now.
But here's the darkness. So, I was on the hiring committee at the United States Attorney's Office for the District of Columbia for 20 years. Why? And that was an extra duty. That was not an assigned duty. But I had a searing interest in the quality of the attorneys that we decided were up to the task of dealing with, ultimately what boils down to the liberty interests of our fellow human beings. That is a weighty responsibility when you have the power in your hands to take away somebody's liberty and imprison them. So when I started there at the U.S. Attorney's Office, we had a rule that you had to have at least 5 years of experience as a lawyer before we would even look at your application. So that was for openers. Now, just to paint a complete picture here, when I left the U.S. Attorney's Office decades later, we had altered our policy. We were actually interviewing people out of 1-year clerkship. So you graduated law school, passed the bar, you clerked for a judge for 1 year. Yeah. We would interview those people. I disagreed with the change in policy. You know what it was driven by? It was driven by money, because we could basically hire 2 law clerks for the price of 1 experienced attorney. I disagreed with it because I thought it was too weighty a responsibility to put in the hands of somebody with virtually no legal experience. But dangling bonuses in front of law grads saying, come on, join us, work to take, people's liberty away. That is a little bit of insanity, but it is very telling. People do not want to associate themselves with this Department of Justice leadership. And listen, they've gutted the civil rights section. They've gutted the public integrity section, the PIN. They've gutted, the environmental protection, environmental enforcement. You go on and on and on. Yeah. And all they want are, people who are inexperienced, weak, perhaps ideological, and are willing to serve the interests of Donald Trump rather than the interests of the American people. And that is a very dire circumstance for our nation.
Yeah. And, we kept hearing about the so-called deep state when Trump was running for office, but these folks are going to remain. They'll be there. They accepted the $25,000 signing bonus out of Podunk Law School, and here they are. And a problem for a different time, but we're gonna have to figure out what to do with these people who seem more loyal to Trump.
We don't come in, and I would not advocate for coming in and just firing everybody who was hired during the Trump administration. But you do have to stress test people to make sure they're up to the task, that they are going to pursue investigations and prosecutions without fear or favor and completely free of ideology and politics. And that's the way we did it. That's the way I did it. My colleagues did it. Our entire careers, and we're just going to need to ensure that is what we do moving forward.
No, if we were to fire everybody, we'd be doing exactly what's happening across the government right now, particularly at my old agency, just people being walked out. And we don't want to do that. We want merit. We want to base it on your, how you're prosecuting cases, ethics and integrity. Speaking of ethics and integrity, Glenn, let's jump to the Supreme Court. And boy, we could spend 2 hours on that. But a couple things got my attention recently. One, King Charles we had a state dinner for King Charles at the White House. Somehow we pulled off a state dinner without the $1 million ballroom. But on the invite list and in attendance were conservative members of the U.S. Supreme Court in their white tie and tails or whatever they wore. Tell us what you think about that. We don't know for sure, so I want to be careful, although I think I know the answer. I don't believe that the left side of the Supreme Court was invited, but whether they were or not, they didn't show up. And so what do you think of that? And why not throw in Gorsuch, Justice Neil Gorsuch, appearing on Fox News to have a chat with that far-right platform? In fact, before you answer, Sean, why don't we play the clip of Gorsuch on his favorite news platform?
Help make those ideals possible for us.
Yes, sir. As an originalist, how do you balance the literal text of the Constitution with more modern issues that maybe the framers couldn't have anticipated, like AI or internet issues?
Well, one of the things that the framers of the Declaration really wanted was independent judges to interpret and apply the law who are not bound down by politics. They fought a revolution against a king who had taken control of the judiciary himself. Mm-hmm. And so an originalist tries to be faithful to the original written word of the Constitution and apply it. Yes, it has to be applied to new facts and circumstances, but the terms of that document cannot be changed by 9 old people in Washington. That's not our job.
Yes, sir.
Wow. So I guess, unbelievable that he seems to feel the need to go on a roadshow, I guess, at far right stations and talk about how loyal he is to the Constitution, and we don't have kings. Fantastic. But what do you think writ large how should a Supreme Court justice conduct themselves with regard to invites to the White House state dinners or going exclusively, seemingly, on far right TV? Do they even have an ethics or guideline policy at this point?
No, there's no mandatory code of ethics for Supreme Court justices. I believe they are they are 9 of the only federal government employees who operate in an ethics-free zone. They have no mandatory rules of ethics that govern them. That's problematic, to say the least. I see Gorsuch going on Fox News as a kind of a reputation rehabilitation tour, maybe, that he's on. Not that the folks who watch Fox News necessarily are troubled by what this Supreme Court is doing, other than maybe the tariffs case and a few others. But I think it's ill-advised. I think it's improper in the extreme when it comes to going to White House functions. What you are signaling there as a Supreme Court justice attending White House functions is that you're there supporting the administration. You are, you're showing a lack of impartiality, independence. Yeah. And, it's pretty horrific that it has come to this. It used to be that I think justices who were sort of both right-leaning and left-leaning understood the importance of appearing independent, not tethering themselves to one administration or another. But, these justices seem to have abandoned that sort of practice, even if it wasn't a rule that was codified somewhere. But, I think what speaks loudest is really their opinions, particularly on the shadow docket. So when I hear Gorsuch, chatting about, being an originalist or a textualist, I would ask him, well, Justice Gorsuch, just do me a favor. All right. Maybe because I'm a product of public school education. Just show me in the Constitution where it says a president has absolute immunity against prosecution. He can violate all of the laws of our nation with impunity. Because the part of the Constitution that jumps out at me is when it says he actually has an obligation to take care that the laws of the nation be faithfully executed. So I've missed the original text that gives him the immunity of kings. So please point that out. Maybe that's in a footnote that I missed somewhere.
Yeah, he's got some gall to get on and talk about how we don't have kings, and the court decisions are getting us about as close as we've ever been to a king with near total immunity. And I just got to tell you, the sight of Justice Kavanaugh in that white tie and tails at the dinner for the king, I just think I saw that as thumbing his nose. I really did. He's rubbing our nose in it, saying, yeah, not only am I not even considering the optics of this, I want you to see me here with my wife. Same thing for Clarence Thomas and the others. And I want you to weep over the fact that I'm having dinner with King Charles. Yeah, I just, that's how I interpreted it. It's ugly stuff.
They're rubbing our noses in it, just as DOJ is rubbing our nose in its lawlessness.
Yeah. We started the discussion on this show with the news that the FBI executed a search warrant at the highest ranking Virginia state senator's business and home. And it seems, at least it seems, to be vindictive based on her role on redistricting. There's another big vindictive appearing case going on, and we've already alluded to it, and that's Jim Comey, former FBI director, fired by Trump in his first term. And now we've got a grand jury indictment because he photographed an arrangement of shells that said 8647. Walk us through, you've presented to countless probably grand juries. Walk us through a grand jury presentation and what in the world this might have looked like to grand jurors. How do you convince grand jurors that an arrangement of shells that say 8647 is a threat against the president of the United States?
You cannot convince them based on those facts, based on the applicable law, based on the constitutional protections of the First Amendment's free speech rights, particularly in the political speech arena. You cannot, unless there is something out there, a smoking gun, where James Comey wrote in an email, listen up, everybody, I intended this as a threat to assassinate the president. Still, I don't think it would be perceived that way because the dictionary definition of the slang term 86 does not include kill or assassinate. We can talk about how it was born of the restaurant industry. Hey, we ran out of meatloaf. You got 86 meatloaf from the menu.
Or in a bar, stop serving that guy. 86.
You got 86. That guy, he's drunk, right? So there is no, and I don't care if there was a Hollywood mob movie that says, "Hey, we got 86 act." That does not make for a supportable indictment. But just real quickly to talk through the grand jury presentation, you go in as a prosecutor, you present the evidence that you believe shows, one, a crime was committed, and two, you have adequate evidence of the identity of the perpetrator such that you ask the grand jury to vote out an indictment. But here's what people may not know. So first of all, it's our show in the grand jury. No defense attorney, no judge. It's us, the grand jurors, and a court reporter taking down every word we say. But we have a dual responsibility. We are presenting the evidence in our role as a prosecutor. We are also the legal advisor to the grand jury. So what we have to do is say, let me give you a fair, balanced recitation of the elements of the crime, what the evidence must show, must satisfy, must fulfill if you are to vote in favor of an indictment. And we've got to call that right down the middle. We're not really advocates at that moment. We are literally the legal advisor to the grand jury. Frank, I can envision no scenario where the prosecutor went into the grand jury, presented the evidence we've all seen about the 8647 seashell arrangement that Comey snapped a picture of, put up on Instagram and said, hey, look at this, a cool seashell arrangement I saw on my walk on the beach this morning. There is no set of facts and circumstances supporting a criminal indictment for that conduct. So what I think that will lead to is the judge ordering that the grand jury minutes, the tapes, the exhibits, the audio recordings, all of it be given to James Comey's defense attorneys. Now, maybe the judge starts incrementally by saying, give it to me first.
Okay.
I will examine it in chambers without the parties seeing it, without the defense seeing it, and I'll make a decision as to whether it was improper such that I should disclose it to Comey's lawyers. The test is not that well defined. The test is if there is a particularized need in the judge's determination that outweighs the traditions of grand jury secrecy, then the judge can order disclosure of the grand jury minutes. It is the broad discretion of the judge, and I have to believe the grand jury materials will end up in the hands of James Comey's defense attorney.
Yeah, Pat Fitzgerald, among others, who, correct me if I'm wrong, because if you're feeling, if our listeners are feeling like this is deja vu all over again, as Yogi Berra said, didn't we get a grand jury transcript when Comey was prosecuted in the Eastern District of Virginia?
We did, and that's what resulted in the case being thrown out because the indictment was unlawfully obtained by Lindsay Halligan. They didn't even get to the vindictive prosecution claim. They didn't have to. Yeah,
unbelievable. And you think that the mere, I don't want to say mere, but the legal disconnect between a shell arrangement and intent to threaten the life of the U.S. president, you think that disconnect, without necessarily, is inherently wrong or problematic enough to get the judge to say, yeah, I want to see this transcript?
I think that's probably enough. And here's the thing. You know, Todd Blanche went on some of the Sunday news shows. Oh, well, we have more evidence. You know, two things. One, he handed up to Comey on a silver platter the defense of selective prosecution by saying, sure, there are thousands of people who say 8647, who posted, who wear it on their T-shirts. They display it, and we got prosecuted exactly. None of them. You don't need to be a lawyer to see the selective nature of that prosecution.
And folks out there, we did not coordinate this, but we just happen to have that clip of Todd Blanche on a Sunday morning show really screwing up this case against Comey. Why don't we play that clip?
The image, excuse me, is part of what led to this indictment. Yes. It is worth noting that on Amazon.com, we looked this up, there are dozens of products with the same terminology. We're showing it right here, 8647 being sold and purchased right now. Should individuals selling or buying 8647 merchandise be concerned that they're going to be prosecuted by the DOJ?
This isn't about a single incident. Okay, this isn't, I mean, of course not. That's posted constantly. That phrase is used constantly. There are constantly men and women who choose to make threatening statements against President Trump. Every one of those statements do not result in indictments, of course. There are facts, there are circumstances, there are investigations that have to take place, and we have charged dozens and dozens of men and women this year with threatening President Trump and others. So this isn't a new charge we're bringing.
Just to be very clear, you are suggesting the seashells themselves are not at the root of this indictment.
No, I am suggesting that every single case depends on the investigation that's done. And of course, the seashells are part of that case.
You know what, Frank? If there was other incriminating evidence or information, you can bet DOJ would have dumped it into that indictment, right? And that sort of, and listen, Todd Blanche has been going on the Sunday shows and misrepresenting evidence in multiple cases. He got caught doing it in the Southern Poverty Law Center case, and I don't want to get off track here, but he literally said on one Sunday show or on one TV broadcast, there is no evidence that the Southern Poverty Law Center shared any information with the FBI or law enforcement authorities. And then he had to go crawling back on another Fox program and say, of course they give evidence selectively over time. It's well documented and everybody knows that. Well, everybody except you last week, Todd. Everybody else, I guess, knew it. But I mean, come on. He has completely disqualified himself as an honest broker of the facts.
Right. And that may qualify him just perfectly for Todd for him to be the next Attorney General of the United States, which he seems
But
to be.
he's not very good at being a consigliere. I'm starting to believe Pam Bondi was actually a better consigliere to Donald Trump's mob boss than Todd. Todd is just stepping on it left and right.
Yeah, it is. It's mind-boggling, and if he may meet the same fate as Pam Bondi if these cases just continue to crash and burn. His boss will not be happy. So one of the things with all that's going on, and I cover a lot of national security coverage, terrorism, espionage, law enforcement, but I refuse to let go with all of that's going on, the Iran war and everything else. I still can't let go of Epstein. I can't let go of the victims and the idea of accountability and the fact that, as many are saying, there still may be 3 million documents that we're not seeing. And now we're hearing buzz about Ghislaine Maxwell possibly getting a pardon. I paid a visit to that camp, minimum security, low security camp that she's in. And yes, of course, she's got a therapy dog. And yes, she can eat her meals in her dormitory. And she gets to go to the gym when she wants to. But let's face it, she's still locked up. And she's, my opinion now, I think she's getting antsy. I think she's getting impatient. And I wouldn't be surprised if she's threatening to talk about what she knows. And so this may have generated the buzz about a pardon. But educate us a little bit about presidential pardon power, which I know is vast. Todd Blanche is in this picture again. He's the one who interviewed her. We got nothing significant out of her other than Donald Trump walks on water. Where are we going with potentially Ghislaine? And then, do you see any light at the end of the tunnel with regard to getting the additional Epstein documents out?
Yeah. So first of all, with respect to whether Ghislaine Maxwell is getting antsy, and I think you said she may be, wanting to start talking about what she knows. Here's the problem, Frank. Todd Blanche already locked her into her lies because he went down to that prison in Florida and he accepted from her all of her lies. I did nothing wrong. Epstein did nothing wrong. Trump did nothing wrong. We're all pure as the driven snow. There's a reason he elicited that and accepted it uncritically. That's one of the reasons I believe they fired Maureen Comey not long before that interview, because she could have participated and called Ghislaine Maxwell's bluff with the mountain of evidence that was used to convict her. But Todd Blanche didn't do any of that. He accepted all those lies. What does that do? It locks her in to those lies, because now if she tells the truth about what she did, what Trump did, what Epstein did, one, she's contradicting herself. So she made a false statement to a federal government official previously in the interview that she had with Todd Blanche. So she's locked in. So one, nobody's going to believe her. And two, she could be charged with a 5-year federal felony, a 18 United States Code section 1001 false statement for each lie she told. So she's got nowhere to go but continue to stick to those lies and hope that a commutation or a pardon comes rolling in. I almost never quote Bill Barr as the authority for any proposition. But in his testimony before Congress, when he was asked if the president issued somebody a pardon to gain their silence because that person could implicate or incriminate the president, would that be legal? Bill Barr said, no, that would be unlawful. That would be a crime. Now, the Supreme Court might trump that opinion, no pun intended. But, here's what I believe we have to do. And I think we're going to get to the accountability discussion eventually. What we have to do is go into court when the rule of law comes back into the light of day and challenge every corruptly delivered pardon. And let judges wrestle with the issue of whether a president is king and the pardon power is beyond the reach of the court. Because if it is, Frank, he can order the Army or his DOJ officials to go to Fort Knox, unload all of the government's assets, money, gold bars, whatever we keep in Fort Knox. I have a cartoon vision of Fort Knox where you open it, there's all gold bars piled up. That's probably not accurate.
You mean there's not?
I don't know. I saw it on Bugs Bunny. And then he could say, deliver it to me. I'm going to distribute it to my family members, and then I'm going to pardon you all. And do we really think the federal judiciary, up to and including the Supreme Court, would say, yes, that's just what the pardon power was designed to allow? Right. I don't think so. I will take a case to trial and lose it. I will take a motion to court and lose it if it's the right battle to fight. But you can't make the shot you don't take. And we've got to take these shots once the rule of law comes back into the light of day.
Boy, we'd have to ask our friend Kim Whaley,
yeah,
who is a pardon expert, on whether, or maybe you know the answer to this, whether throughout history there's been a decision that a presidential pardon or commutation was unlawful. Or
I don't believe, well, there is one from 1915. It's in the case of United States versus George Burdick. George Burdick was a newspaper editor in New York, and the president tried to force a pardon on him to extinguish a Fifth Amendment privilege against self-incrimination that he was trying to use to prevent being compelled to give information about a source. And the Supreme Court in the Burdick case said there are limitations on the pardon power. A pardon carries with it an imputation of guilt, and accepting a pardon is at least some confession of guilt, and a president may not force a pardon on somebody. Now, that may not be a lot, but it's something that chips away at the absolute nature of the pardon power.
Yeah. Wow. Good reference. Pulled that one out. Thank you for that. So larger question, where do you fall if all of this ends up in the courts, perhaps someday, particularly the larger question of accountability for all of this regime? Where do you fall with regard to a solution for the Supreme Court? Are you getting more closer to the possibility of expanding the court? Do you think that's I think it makes sense for multiple reasons. So first of all, 9 is not a magic number. We have had as few as 5 Supreme Court justices on the court during the existence of our nation and of the court. We've had as many as 10. 9 is not a magic number. It would require legislation to expand the court. But here's the thing. We have expanded the number of trial court judges. Why? To norm for the expanding population and the increase in caseloads. We have expanded the number of appeals, courts of appeals judges, again, to norm for the increase in the population. We have 13 federal jurisdictions, and in theory, 1 Supreme Court justice is supposed to have supervisory responsibility over each of the 13, but some have to double up because we foolishly have never increased the number of Supreme Court justices. Now, I think the time is right. I think we have to also do it to try to address and attack what I see as this sort of radical right-wing bloc that have just departed from the text of the Constitution, and they are forever expanding executive power in ways that are not just unhealthy for our democracy, but contrary, I maintain, to the express terms of the Constitution. So I think there are lots of good reasons to do it. Accomplishing it is another thing, but I am a proponent of, 1, a mandatory code of ethics that are actually enforceable, that if Supreme Court justices violate, for example, our financial disclosure laws, they're required to disclose gifts that they're given, and yet it seems like people like Thomas and Alito are not doing that. Well, then you need a mandatory code of ethics that are actually enforceable, and increasing the number of justices. I am a proponent of those things. Of course, I guess devil's advocate there would be, well, that's expanding the court sounds great when Democrats are in power, or when the party you like is in power. And I know it's the gift that keeps on giving if they serve for life, but do you see any issues with that? Like
none. Because listen, no matter what the Democrats do or don't do, the Republicans are going to abuse their power. They're going to bend the knee to, the Republicans in Congress have completely abdicated their responsibility to perform oversight on a runaway corrupt executive branch. So no matter what we do or don't do, the Republicans, it seems, are intent on abusing the American people and abusing governmental power. So why would we just tie our hands behind our back and say, we're not going to respond in kind? The real challenge for me, and I always go back to my football days. My pop was a high school football coach. I lived and breathed football growing up. If the other team is violating the rules, they're putting 13 men on the field, every play, and we're sticking to 11 men on the field because it's the right thing to do. Where does that get us? It gets us losing every game, every season. Yeah. I'm not an advocate for violating the rules. I'm a rule follower by nature, but we also have to fight with both gloves off. So there is friction between those two things.
So let's go to the larger issue of accountability when all of this is over, if it happens, and we, maybe statutes of limitations have expired. What does accountability look like? Are we talking about Nuremberg type trials? Are we talking about the International Criminal Court? Are we talking about Congress, where some of these people, maybe Todd Blanche, maybe Pam Bondi, refuse to show up for a congressional subpoena? Where do you see accountability going?
I think we need our version of the Nuremberg trials. Whether it's going to be the American Accountability Project or something else. For me, this is what accountability looks like. Once the rule of law comes back into the light of day, we have a law-abiding president and a law-enforcing attorney general. We present to grand juries honestly, ethically, impartially, but really aggressively. We present all of the evidence of the crimes of, let me just pick a crime, Pam Bondi lying to Congress and saying there is no evidence in the Epstein files of Donald Trump committing every crime, and everybody knows that. I think that is pretty much a verbatim quote. Then when she reluctantly felt compelled to disclose those FBI 302s, those write-ups of a witness interview with a 13 to 15-year-old girl, Frank, who presented direct evidence out of the mouth of the victim. This is what Donald Trump did to me. That's not even circumstantial evidence. That's direct evidence of Donald Trump committing a crime. And mind you, Pam Bondi didn't qualify her testimony with there's no credible evidence. She didn't even use the word credible. So she lied to Congress, inarguably, shooting fish in a barrel, making that false statement case. Yeah. You present all of the evidence to a grand jury, and you let the grand jurors, sitting as the conscience of the community, decide if there's enough to indict. And if there is, you take them to trial. You try the crap out of the case. Then you deliver it to the hands of those 12 people sitting in a wooden box, again, as the conscience of the community. And the accountability job is done at that moment. You don't even have to await the verdict because you've done everything that you need to do to hold folk accountable. Then you let the people decide. And I have to believe, just like that jury sitting in New York who banged Trump out on 34 felonies in violation of New York state law, in a New York minute, the juries will get it right. That's what accountability looks like to this old process.
For sure. Yeah. No, thank you. I also go there. In fact, people are probably tired of me hearing that you need to go to Netflix and watch the Nuremberg movie. It's there now for free, and it's just phenomenal on how that played out. And credible victims. There was a victim deemed credible by DOJ, so much so they put her on the stand in the Ghislaine Maxwell prosecution. So you can't say she's not credible as to Trump or others, but she was credible to prosecute Ghislaine. It's a big mess. We need accountability. We need you to continue the work you're doing with Justice Matters. Remind folks, as if they don't know, where they can find you and follow your work.
So, Frank, I think the most fun we have on any of the platforms is on Substack. It's independent journalism, which is where you are. We both used to be MSNBC contributors. We both decided to leave, and we're now 100% independent. And that's so important in this day and age when corporate media has dropped the ball. So if you come over on Substack, we do community meetings every night at about 8:30 p.m. Eastern time. We talk about the legal issue of the day. We talk about how we can engage in this fight for the rule of law, for the Constitution, for democracy. We have a lot of fun. It's a little irreverent, and it is free. I don't put anything behind a paywall on any platform. You can support me if you choose to, but you don't have to. Come on over to Substack at 8:30 p.m. See if you enjoy our community meetings. And then the other place, you can go over to my Justice Matters YouTube channel, which I've had up and running for many years now. And I post a legal analysis video over there every day. Also free, but hit subscribe, even though it's free, because that kind of helps with the analytics gods or whatever.
Oh yeah, it generates, YouTube perks up when they see the subscriptions. They do, for sure. Hey, thanks for joining me. I know how busy you are, but I also know how much our viewers loved hearing from you. Check out Glenn on Substack and YouTube, and we'll have to have him on sometime later. But thank you, Glenn.
Great being with you, Frank.
Thanks. Stay well.